Good morning, everybody. Welcome to our joint presentation on workplace benefit liabilities in the COVID-19 era. Thank you very much for joining us today. We have a lot of people joining us today. This is clearly a very live and pressing issue for people. I know that everyone is really trying to sort out all kinds of new law. We are, as lawyers and benefit experts, we're also learning on the fly here of new legislation coming out, and we wanted to present this together with you so that we could help you out with some best practices, and then just to give you an update on where the legal and benefits landscape is sitting for today, at least. So joining me today are my colleague Hillary Page, a fellow lawyer at SpringLaw, and then our dear friend Gisela Carrera as well, president of Benchmark Benefit Solutions. I'm just going to turn it over to each of them to give a brief introduction of themselves. Go ahead, Gisela.
So Gisela, president of Benchmark Benefit Solutions. I've been in the employee benefits industry for about 25 years. Spent the first 12 years on the carrier side between actuarial services, pricing, sales, and for the past 12 years, I've been on the consulting side. And for those of you who know me, you know that I can get very passionate and I can get really, really nerdy about my benefits. So I'll try to tame myself down today and let the legal experts take the lead here.
Okay. Hillary?
Okay, and as Lisa said, I'm a lawyer, an employment and labor lawyer at SpringLaw. I work with Lisa, and we are a virtual firm in Toronto. So we're in our remote offices, as we always are, practicing social distancing every day.
That's true. Yes. Okay, and I'm a founder and an employment and contracts lawyer at SpringLaw as well. And we help employers and executives with their innovative legal solutions in their workplace. And because we're remote and virtual, we are comfortable with tech and find this new era not much of a switch for us, but we're definitely feeling a ton of questions from our colleagues at the bar and also our clients who are really struggling with how to get through this unprecedented moment. So without further ado, let's jump over into our overall roadmap of what we're going to talk about today. We want to walk through, what the changing landscape of employment benefits are during a global pandemic. We divided the huge amount of content into three main sections. What we wanted to do is first just lay out what is the existing options available for employee relief, and then for employer income relief, and then we're going to really dig into the meat of the whole presentation, the reducing the risks. And really, we've had so many questions from our clients, both on the benefit carrier side, the benefit side with Gisela's clients, and then SpringLaw's legal clients around how to handle the benefits. So we've compiled all of these questions. We've been fielding questions from you, the attendees, over the last couple of days, and we will really dig into those in section 3. So bear with us as we zip through sections 1 and 2 to just lay out what are your options to pick from, what are some of the math options to think through when you're looking at your options as an employer. It's good to know mathematically what might be available to your employees to help make your decisions around layoffs, terminations, continuing benefits, etc. Our goal of the webinar today is to help out with understanding the options available to you. And then, we are learning on the fly as well. The law is changing literally day by day, so we're doing our best to stay up to date. But more than anything, we hope that we can really help you with issue spot today and help you understand what options are and where some of the particularly big red flags might be. Throughout our presentation, we're going to try and have 3 points of view for each of the questions that we answer. We'll first give you the I don't know which order exactly. The three points of view that we'll do is the official insurance policy view, what is the official legal position, and then practically, what is the the reality facing all of us in this unprecedented global pandemic, and how will we somehow get through it all. So this will be a mix of crystal balling and legal advice, and then insurance expertise. Okay, our first section, I'm going to hand it over to Hillary to jump in and give you the outline of income relief options for employees.
Yeah, so I'm just gonna kind of quickly hammer through this stuff. As Lisa said, just to sort of set the lay of the land, and a lot of this stuff is brand new as the federal government and the provincial government are changing the law and changing relief plans available to employees and employers. So, everything we talk about is as current as we know it to be, but things are changing day to day. And I'll also just say, as sort of an overall, we're going to focus on Ontario just because that's where we are, but at SpringLaw we do advise on all of Canada other than Quebec, and there will be different acts and different requirements in terms of layoffs, terminations in the different provinces. So if you have a specific provincial question that we don't cover, maybe just shoot us an email afterwards. So Ontario did announce this new COVID-19 leave. This is a job protection leave, so it's not a benefit. It does not mean that you have to pay employees who are on this leave or anything like that. Basically, it just covers employees who are ill, caregiving for someone who is ill, in quarantine because they've returned from travel, or they've been told to be in quarantine because they're in contact with someone who is ill, or employees who are caring for their children because schools are closed. They can assert their right to this leave and go on this leave, and that just means that as an employer you can't terminate them or lay them off because they're on this leave. Practically, for an employer, you don't have to pay them while they're on the leave. You do have to continue their benefits if that's a normal part of their employment while they're on the leave. So a couple of questions, we're just peppering these in, and these are real questions that we've gotten from our clients. And one is, can I ask employees to volunteer for this unpaid leave? You could. They need to meet the criteria for the leave legally. So if they don't have kids to take care of, if they're not ill, if they're not in quarantine, they may not meet the criteria for the leave. If you as an employer are still having them come into work, which would only really be the case if you are in an essential services business right now, then and you were concerned that they were maybe spreading if they had symptoms and they weren't staying home, you could put them onto this leave. So that's sort of the only way an employer can sort of force anyone onto the leave is in that situation. And just this last question, can I require employees to use up their unpaid vacation or their unused vacation and sick leave time first? As an employer, you can always direct when your employee takes vacation. Sick leave, they should meet the criteria to take a sick leave, but presumably they would in this situation. So you could technically require them to use up that time first, but because you don't have to pay them when they're on this leave, it may not make practical sense for you to do that because you're going to be paying them if they're using their vacation or their paid sick time. So there's some other options for employees. These are federal programs, and so these are income replacement programs. So EI, regular EI has changed a little bit. Well, it actually hasn't changed that much. I think the wait time, there is still a wait time for regular EI. So some people are confused, but the waiting period has been removed for sick EI, which I'll get to in a second. But for regular EI, there's still that waiting period. Regular EI is 55% of your insurable earnings, and the insurable earning maximum is that $54,200 amount. So the weekly maximum someone can make on EI or get from EI is $573 a week. The length of time you can stay on EI varies depending on how many insurable hours you have banked as an employee, and that will also be impacted by how long it's been since your last EI leave. So if you were on a leave within the past year, that will have used some of your EI hours, and you may have trouble meeting that 700-hour threshold. The threshold, as well as the length of EI, is different from region to region, depending on the unemployment rate in that region. So we just have here the Toronto rate, but it varies. And I do feel like that's going to be impacted just because we're seeing unemployment rates skyrocketing right now with everybody being laid off. The Canada Emergency Response Benefit is a benefit that was just announced this week by the federal government. So this is another income replacement benefit. And it's different from EI because it applies to people who wouldn't otherwise be eligible for EI. So contract workers and self-employed people, generally they don't pay into EI and they can't take advantage of EI. So it's a benefit available to them. It's $500 a week for 16 weeks. So it's a shorter term benefit than EI. I wouldn't be surprised if we see that extended. It's a little bit less money than EI if you are making the more than $54,200. Probably people who are making less than that, they're going to end up with more money in their pocket if they go on the CERB benefit versus EI. And if you are EI eligible as an employee, you can choose to go on this benefit instead, or you can go on this benefit and then when you finish your 16 weeks, if you still need income support, you could apply to EI at that point. So that's a new, really flexible option from the government. Yeah. So EI sick benefits, these are the ones that have changed in terms of the waiting period being removed. So with normal EI, you have to wait 1 week, and it's like an insurance deductible. Before you start getting benefits. So you're unemployed for 1 week, you get no pay for 1 week, and then you'll start getting benefits the second week. Sick benefits, you'll get them right away. And in any case of EI, it can take up to a month to start receiving your benefits, but you'll get them retroactively. So your first check will cover several weeks of time. They're the same amount as regular EI benefits there. So that's the same. And then the new thing also with these is that there's no medical evidence required, no medical certificate anymore. So if you have a COVID related reason for needing to go on these benefits, I assume you just like tick a box, whereas before you would have needed to substantiate medically that you were sick and unable to work. Parents who might be on EI for maternity or parental leave benefits, there's no real change there. And for most of those people, let's say they were looking to come back from leave soon, they will have exhausted their EI hours, most likely. They will have used up all their EI, and they're going to need to work for another year or another 700 hours or whatever the rate is in the region to become eligible for EI again. I do think that those people could take advantage of the CERB benefit though. STD benefits. So some employees who are ill with COVID, they may be eligible to go on STD. That will depend, on the insurance plan, and we'll chat a bit more about that later. There are employees in the situation where they might be on a leave right now, and then the employer wants to make a change to their employment because maybe they're laying off every employee. So we had a couple questions about that. So if an employee has already applied for STD and before the employer's contemplated the layoff, I think we need to be reasonable and let that STD process finish before we decide what to do with that employee's employment. And generally, you don't want to lay off an employee who is on STD or LTD because, unless you're self-insured, as an employer, you're probably not paying them a salary anyway. So that's the advantage of a layoff, is you're not paying a salary to that person. And you could risk human rights infringements if you were to do something like that. So generally, you just want to be a little bit careful with employees who are on any sort of leave. Then paperwork employees will need to access these benefits. Employees will need an ROE. So when an employer stops paying an employee for whatever reason, maybe because they've been laid off, because the employees decided to go on the new COVID leave, whatever, the employer needs to issue an ROE, a record of employment, and submit that to Service Canada. Where there's a layoff, we're going to use code A, shortage of work, in block 16. If it's a COVID leave, we're just using other, and the direction from Service Canada is not to write anything in the comments. So, because they just don't want to read any comments. We don't, and and when you're making a change to your employees' employment in any way, so laying off, reducing pay, putting them on a leave, as a lawyer, I'm always going to say put it in writing. So even if you don't think you have to put it in writing, I just told them, it's always a good idea just to follow up with an email, confirm everything in writing is what we suggest, just so that it's clear. The new CERB benefit, we don't expect that people are going to need any paperwork from an employer to access that necessarily, because it is available to people who aren't employees. So like an independent contractor is not going to have an employer who's going to issue them an ROE. So we don't know how that's going to work. The applications are going to come online probably next week or the week after, so early April. But I expect that it's not going to, it's probably just going to be like tick a box. Yes, I've lost my job because of COVID. Oops. Okay, next. So we're moving on now to income relief options for employers. So a lot of employers we're seeing have lost their revenue streams, right? So canceled events, canceled contracts, restaurants closed, and what are employers to do? What help is available there? So employers are looking at their spending, and obviously a big expense for most employers is payroll. So how can we deal with employees, and if there's no work, like what are we going to do? So there are sort of two main options. If your employee is not on some other type of leave, employers can consider a layoff or termination. So the difference between a layoff and a termination: a layoff is temporary. So the employer is just saying, okay, I don't have any work for you right now, but I expect to recover and I expect to bring you back. If you think about it, like a seasonal worker gets laid off every season, right? So we're just laying them off for a period of time, but expecting that they will be able to come back. The timelines and the requirements for layoffs differ province to province. Some provinces require that employees be given notice of a layoff. So like, I'm going to lay you off in 2 weeks' time. And then the length of the layoff differs also from province to province. In Ontario, if you don't continue their benefits or top up their pay in some way during that layoff, the maximum duration is 13 weeks. It can be longer if you continue their benefits, can be up to 35 weeks. If the layoff goes for longer than those specified times, that will trigger a termination, and then you'll owe termination pay. So when you're laying off initially, the employer can just stop paying, issue the ROE with code A, and there's no additional payment required to the employee at that time. Termination ends the employment relationship. This is like firing somebody, and in most cases, you're going to owe that employee termination pay, or what we call notice. So that's usually going to be, weeks to months of pay that you would owe the employee upon terminating their employment. So employers can get some help with paying their employees' salaries through the supplementary unemployment benefit plan. So this is this is actually not a help to pay the employees. This is a way that employers can help their employees. So employers can lay people off put them on, the employees can go on EI, and I should just say that whether or not an employee is eligible for EI is really up to that employee. The employer doesn't have any control over whether or not an employee is eligible for EI. It depends on how long the employee has been paying into EI and so on. But if an employee is on EI, then employer can top up their pay if they want to under the supplementary unemployment benefit plan. And this would allow the employer to extend the length of the extend the length of the temporary layoff in Ontario. It helps the employee because the employee's getting, more money in their pocket, but the employer isn't having to pay them, full salary. But this is, in this instance, employees are not working, so you're just topping up, and this sort of an analogy, or basically the same thing, is topping up someone who's on a parental leave, right? So you're just paying them a bit extra, and you need to register it with this plan, or EI is going to take that money and deduct it from the amount of EI that the employee is getting. Employers can also consider work share. So this is a situation where the employees continue to work, but at reduced hours and reduced pay for the employer. And then the work share program through the government tops up the employee's pay. So it's a way that you can keep employees working, but reduce the amount that they are getting paid. So this is a fairly complex program. And it's not available for every job, so it's not available to managers, for example, or owners. And generally you need to have sort of groups of employees who do similar works so that they can actually share work. So you couldn't probably do a work share between, someone who's in marketing and someone who's in programming, because they're not actually able to share work. Another new program is the Small Business Temporary Wage Subsidy Program. So this just helps employers by it tops up pay. So it's, similar to work share, except you wouldn't have to reduce an employee's hours in this situation. So the employer would just be able to pay the employee less, and the government will top up 10% of an employee's pay. So this isn't available to every business, but it is available to small businesses, not-for-profits, registered charities. And the sort of definition of the small business who it's available to is my last bullet there, the Canadian-controlled private corporation with taxable capital employed in Canada of less than 15 million for the preceding tax year. The government has also introduced a couple other measures that aren't really, directly related to employment, but those are just listed there with the deferral of tax payments, tax credits. Just let you guys read those. And here we are, part 3. So that was the high-speed legal lessons.
Your boot camp, half of which was brand new to us as well. A week ago, yesterday, today. We're
going to take a quick sip.
Yeah.
So now we're just going to get into some practical stuff and how employers can reduce their risk in this current sort of landscape. So I'm just going to read out some questions, and we're just going to answer them. And I see we're also getting some questions.
Yeah, if there are any other questions, feel free to put that in the chat. We're keeping an eye on any questions that are coming through. A lot of these questions are questions that people did email us ahead of time, but for sure, if we can't get to your questions, just email any one of us afterwards, and we can give you a hand.
Yeah, so I guess we'll just do a couple of our questions on this slide, and then maybe we can do a couple of the audience questions. So I'll just start with the first question. We didn't include a layoff section in the employment contract. Can I lay off an employee anyway?
So this is probably one of the main questions we're getting from everybody all the time, and really sets the foundation for all of this. And it's what you're probably all reading in the newspapers right now. In Canada, it is every employment relationship has a either a contract or an implied contract. So even and so every term and condition of work is governed by contract, even if it's only implied. What this means, and I say this especially for anyone who is, you know, with a U.S. company or has a U.S. parent, because we don't have at will here. You can't just lay people off and move on. In Canada, unless there's a specific provision in the contract that permits layoff, it's considered a constructive dismissal. It's the employer unilaterally imposing an adverse term and breaching the contract. Now, what we're seeing, so that's the legal piece, right? The practical reality is, in the midst of a global pandemic right now, a lot of businesses are facing the naked reality of either the company goes belly up or they lay people off. And so if there's a conversation with employees and they agree that yes, we'll accept the layoff for a period of time to try and weather this storm, then there is no exposure for the employer. They can do an agreed upon layoff. What we're of course seeing is many employers just making the decision, and if it's a larger layoff, the logistics of getting an agreement from everybody isn't feasible anyways. And what we anticipate is that the courts are going to have some sympathy for employers. There isn't a big choice for many people. It really is a matter of there's just no money. If there's zero revenue coming in, you know, and if you can forecast over the next several months, if you're a non-essential service, if you're in the restaurant business, or you do speaking gigs, or you know, I mean, we have so many clients that they simply are not allowed to be open right now. You know, is it a constructive dismissal if you lay people off? Technically, yes. Practically, we have to wait and see. So can you lay people off anyways? Is it really a constructive dismissal? Yes, technically. Practically, we have to make some tough business decisions right now.
I'll just jump in regards to the benefits part of it, because that's a question that we get quite a bit from clients in regards to extending benefits for the life, health, dental, long-term disability, and short-term disability. So the standard before all of this has evolved and continues to change every day is that every contract within an insurance contract for life, health, and dental, LTD, STD, is that layoffs would be eligible, anybody on a layoff would be eligible to continue benefits. Depending on the contract of that insurance company, it could be anywhere between 3 months to 6 months. Certain insurance companies will continue to cover the long-term, short-term disability. Some of them will not. However, with everything that has evolved and how things are changing, the insurance industry is coming together. They are becoming flexible to attend to the needs of Canadians. So what we're seeing is that they're now extending the layoff period to 6 months for health, dental, and we're seeing that they're extending it anywhere between 31 days to 3 months for short-term disability and long-term disability benefits. So there is a response in regards to the needs of Canadians today. And of course, as a benefits specialist, we're seeing emails from carriers every day, sometimes twice a day, where they're changing their stand. So it's ever evolving, but we are seeing that flexibility in regards to layoffs.
I'll just pop in. I'll just ask a couple questions that we're getting from the live audience. So I thought this was a good one. What if an employee just refuses to come into work because of COVID-19?
So there's a couple of buckets that this gets put into. First of all, we've got our Occupational Health and Safety Acts across the country in each of the provinces that could be triggered. So if it's a live risk of being injured or being medically compromised, then health and safety laws will be triggered. There are if somebody is having to stay home because it's a reasonable risk, they may be able to claim the COVID leave, certainly in Ontario under our Employment Standards Act, and that becomes a protected leave. no different than if someone, becomes pregnant, they have access to that leave, and it's now a protected leave. You can't fire them because they're pregnant. So I think, if people are refusing to come in because they fear testing positive for a life-threatening disease, a virus, it's going to be hard for an employer to take the stance that they must come in. Now, there's going to be situations if they're on the front lines in the healthcare sector. I think that's going to be a whole other story. That's an essential service, and there'll be probably different rules applying to that.
Yeah, I would say there may be situations where an employer has made reasonable concessions to an employee for their safety, and that if an employee is being unreasonable, which may be a bit of a high threshold given our current climate, but if an employee is being unreasonable given the employer's protections, and they don't have kids to take care of, they're not ill themselves, they don't qualify for that leave, then I would say that that employee has quit.
Mm-hmm. Mm-hmm. And I would hate to be the lawyer on that employer side in that case. That ever went to trial. But yes, technically that would be the case.
Yeah, I'll just do one more question from the audience, and then we get back to our slides. But we've got a lot of questions here. Can you give an employee on COVID-related leave an EI benefit, a top up to EI benefits like you can on maternity leave? So I did address that, and yes, you could do that. You just have to register it under the Supplementary Unemployment Benefits Program. So that's I asked that question. Have we addressed the questions on this slide for the most part, or do you want to talk about the benefit booklet?
Yeah, I just would say, if the benefit booklet is silent on layoffs, a key reason why we put this question is because we're getting people that are asking questions around what are employees entitled to right now, and we just, maybe it's the lawyer in us, but it's important to go back to what piece of paper sets out the promises to the employee, and this applies if you're considering which benefits to continue, whether to pause any, whether to take a holiday on some of them. If there's a contractual promise either through a benefits booklet or an email to employees saying, hey, we've got this new program in place, and everybody is for sure going to get amazing dental care forever, then you've now made a contractual promise to your employees around dental benefits, for example. Now, we're in this unprecedented moment where there's going to be flexibility from adjudicators if employers are acting reasonably and doing their best in a crazy situation. The bottom line is go back to the original source of the promise. What do the insurance policy documents say? What does the employment contract say? What does your collective agreement say about any of this? And then just be careful if there's been any paraphrased communications to employees, so that you know what you have to reconcile as you figure out what can you continue and what can you not continue.
And Lisa, quick question. So if the contract is silent,
Mm-hmm.
There's no reference in the employment contract, there's no communication between the employer, there's nothing in writing, what would you advise then?
Usually it'll say at least in the employment contract, assuming there is an employment contract, that you'll get X amount of dollars per hour a year, and we'll give you benefits. And so in that benefits section, it'll either say, we agree to pay, provide you with specific benefits, or we agree to pay a premium for, contribute to your benefits plan, for example, or provide you with a benefits plan subject to the terms and conditions of the insurer. So there's different ways that the promise is made to employees, but if I think that we start to get into legal nerd territory of the nuances of what the promise is. If there's a past practice and a recent past practice of providing these benefits to people, the employer's on the hook. And if you take it away, it's a contractual breach, probably. Hillary, did you have any comments on that? I know we were talking about this earlier.
So I think it's a contractual breach, but the degree of the contractual breach is what we care about. because sort of all the overarching concept in all of this, which maybe I didn't quite highlight enough in the legal section, is that if an employer is changing an employee's work in a material way, and that would include laying them off, putting them on a work share, reducing their hours, reducing their pay, asking them to do different jobs, potentially taking away their benefits, maybe even like taking away a bonus they got every year. So doing anything like that that's a change, it creates the legal risk that the employee is going to assert a constructive dismissal. And a constructive dismissal is when an employee says, hey, I didn't agree to this. You just fired me from my old job the way it used to be. I don't, and then they assert their termination entitlements, right? So that's sort of when I've been advising, I've been saying, like, this is the worst case scenario. I mean, there are many worst case scenarios, but sort of simply legally speaking, the worst case scenario, if you take away benefits, reduce an employee's pay, is that the employee is going to assert a constructive dismissal, and that you're going to owe them their termination entitlements, which notice, as we call it. So every case is going to be specific regarding, like, was this a material change that would allow the employee to assert a constructive dismissal, right? So, maybe if the only benefit they had was, like, they didn't have the best benefits package, and it wasn't, or they just got it, or, it may be not material to the contract, material enough to allow an employee to assert a constructive dismissal. If you're cutting someone's pay by 25%, that's going to be material, right? So, but then...
And I think it would really vary from one employee to the next, right? Because usually when we look at employee benefits plan, it's usually just 10 to 15% of the workforce population that are really using the plan, right? Mm-hmm. So it may affect the one person that has really high drug claims, and all of a sudden they're left with that financial risk.
Yeah.
To go through that on their own. So it's, kind of thinking about it that way too. It will not affect every single employee, but, just that 10 to 15% that really rely on benefits for their livelihoods.
I think, like, legally speaking, it wouldn't particularly matter if the employee used the benefits a lot or not, because that's something they had access to as part of their remuneration, right? But I think you raise a good point, Gisela. Like, that employee who loses those benefits that they really need and they really use, they're going to be in a worse position and much more motivated to assert a constructive dismissal, and likely much more sympathetic if they should get in front of a judge. So I think, you're absolutely right that those employees could be higher risk. There's tons of questions coming in, so I'll just ask a couple more. Any tips or best practices about allowing employees to work in different jobs from their norm due to increased demand and staff shortages in certain areas? For example, essential businesses. So I think this is, Lisa, do you want to take this one, or?
Well, no, we're going to say the same thing. Yeah, if you can keep your employees busy and keep paying them, absolutely. And I would not worry about things like updating their job description right now, or having them enter into a new contract to reflect that. It just get everyone working and paid. Everybody, I think, is going to, especially for the next month, let's say, it's an emergency situation right now. It is what it is. If you're unionized, make sure you're talking to your union very regularly about what's going on, and get everybody on the same page. But yeah, get people working and paying them if you can, and don't worry about the details for now.
Yeah. Just another question. How long can employees be off for? So in this one, that's going to depend what province you're in and why the employee is off. So in Ontario, if the employee is off on the new COVID leave, that lasts for as long as the state of emergency lasts. So we don't really know how long that will be. If you have an employee on a layoff in Ontario, it can be 13 weeks if you're not providing them with any benefits or supplementary unemployment benefit top-up, or if you're not having them do any work, or it can be up to 35 weeks if you are. So, but it really varies depending on the situation. If you had an employee who was, on a sick leave, they may only be able to get EI sick leave benefits for 15 weeks, but they would have job protection under the Human Rights Code where you couldn't just fire them because they're sick for a long time, like potentially 2 years.
Mm-hmm.
So it really, really depends on the situation.
Let's go to the next. Okay, yeah, perfect. Yeah, because I think this is going to answer. We talked earlier. Slide 18 and 19 could be like a whole week's course, just all the issues that it raises in just these 2 slides. So go ahead.
Okay, sorry. Yeah. So if we're continuing benefits, and so this is all during the layoff, can we continue only some of the benefits?
Gisela, do you want to start with that? I mean, what's the insurance angle of all of that?
So there's 2 sides to it. So the first side, I think I touched on in regards to layoffs. So can we continue benefits? Yes, and carriers are more flexible right now in regards to long-term and short-term disability extension, as I mentioned, anywhere between 31 days to 3 months. In regards to, and I'm not sure, Lisa, if you'd like me to jump, but in regards to just stopping benefits altogether. So right now, insurance companies are giving employers the option, some of them, and the reality is, even if it hasn't been announced by one insurance compared to the other insurance company, they're all pretty much following suit. So if you have an insurance company that's telling you, you can take a premium holiday or you can stop your dental benefits for the next 2 months, and then we'll reinstate the plan and all employees and plan members will once again have access to dental benefits. The issue in that's great because it's from the one end, and that's what we discussed, Lisa and Hillary and I earlier today, it's great because yes, it gives the employer that flexibility to stop premiums from a cash flow perspective. But then we have to think about the legalities around stopping a benefit that has been promised to that employee. So I think that's the 2 parts to it. I think we kind of touched on the layoff side of it. Yes, they can continue benefits, but now there's this other option for employers where they can put a pause on the whole benefit plan for, again, 2 months. And I use that as an example because every carrier will fluctuate from one to the next, or pause one benefit at a time. So I think what we're hearing from our end is, well, what's the risk? From a legal perspective, what is that company's risk?
Well, so what is the risk? There's a couple of components to that because the vast majority of employers will not have a section in the contract that gives them the right to lay people off in the first place. So there is a very big chunk of employers right now that are on gray area ground that that may not have the strict legal right to lay people off in the first place. If employees are agreeing to because they it's that or zero job and being thrown into an economy that is completely stalled right now, if you can get people's consent, then you're good to go. So there's a bunch of layers to the fact that whether or not that layoff is legal. And so once you start, if given that the layoff has this sort of uncertain backdrop, what can you do with the benefits, right? I mean, if they're on this layoff anyways, there's nothing that says that you have to continue the benefits. Now, we are encouraging employers to do so. If you're taking away people's salary, if you can still afford to at least continue the benefits, it's a much safer place to be in the event that the employee does need them. If they become sick, especially if they need access to the EAP services for counseling, everyone is really very stressed out and very worried right now. So having access to counseling services, for example, I think is a very important way for employers to help address their own exposure here and their own liability. Taking away people's livelihood and their access to services like that is not ideal. So, and then if you start, pulling it apart, can you continue only some and not all of the benefits? Again, the more that you can continue to provide that you can afford to provide, the better. But to some extent, it'll be what the insurance company says. So I'm so happy to hear that the insurance companies are coming to the table with flexibility around this. So everybody should be calling their insurer and seeing what options are available, what kind of payment holidays can you take, and whether or not you can continue some but not all. We don't have black and white answers to some of this right now. But the more you can continue benefits, the better. That's my message to every client that I'm talking to right now.
And Lisa, just to keep track of time, it's at 12:45 now. So we're getting a lot of questions. And so if it's okay, we'll keep going. And for those of you who can spare the time and continue online, should we?
Yeah, we'll continue. We'll stay here and continue. We're recording this webinar as we speak, so it will be available after. If you do need to, I know people are busy, and if you do need to drop off, because we said it would only be 45 minutes, which was silly of us to think that only would be 45 minutes, but you need to drop off, fine. We will be emailing out everybody access to the link afterwards. But for anyone else who can stay on, there are a ton of questions coming in, and we still have a few more slides. So we're happy to stay on for a bit longer.
Yeah. I'll just add on to what you were saying there, Lisa, just because we do have a couple of questions on this. If you did maintain benefits during a layoff in Ontario, that would give you access to a longer layoff period. So, so in 13 weeks being the maximum in Ontario, if you didn't continue layoffs. So that's definitely something to consider. And I think that would be the case even if you were only continuing like partial benefits. I think that would probably be sufficient to get it up to 35 weeks. And then someone had an interesting question here. Should we continue benefits from the outset of the layoff if we think the layoff will be longer than 13 weeks, or could we restart the benefits in the 12th week if we think the layoff will be extended? I think you could do that.
Yeah.
But again, like with all the caveats that like really you shouldn't be laying people off anyway, like in terms of a technical legal position. And then someone just had another great question adding on to that. Should we be adding layoff language to our non-union employment letters going forward? Absolutely. We recommend for our clients whose contracts we do include that right to lay off, and that makes your layoff legal if you have that in the contract. So rolling out new contracts or employment letters to existing employees is a whole other discussion, but if you're hiring after this, I would absolutely recommend including that layoff language.
There's another question in regards to employee premiums. So what happens if an employee refuses to pay for premiums during a layoff?
Yeah, that's a great question. So I don't know. Did you want to answer that one, Lisa? Or?
You don't know the answer either, do you? No. Yeah, if they refuse, I mean, if it will depend on how secure the employer is on the layoff in the first place. So if the employer is forcing people on a really sketchy layoff that they maybe aren't allowed to in the first place, then I think you're not coming to the table with a lot of strength. So if the employer refuses, then if the insurance policy is one that requires 100% participation, that can make it kind of complicated. So then it's a phone call to the insurance, to Giselle to help you. But if it's an optional one, then you can look into whether or not the employee can just have a holiday. But then you get into the complications: can they get back in? Because some policies, if you hop out, you can't hop back in. If you are a small workplace and you're not worried about setting precedents, and there's one person with a particularly unique situation, maybe they're your lowest earner and they really can't afford it, or they've got all kinds of extenuating circumstances, it's also an option to pay their premium, right? I mean, we've talked to a lot of small employers that they have to look their, less than a dozen employees in the eye every day, virtually now, and they know their life stories. They know what's going on at home. They know their economic situation. They know exactly what their livelihood is. And so if they refuse, you can start having individualized options here. For larger employers, that gets really dangerous. It is better to have a system where you roll out the same thing for everybody. But we're in a new situation here, so I think a bit of compassion is going to be important here.
And I would just add, like, from a non-compassionate perspective, that if it's the employee has agreed as part of receiving those benefits that they pay their portion, right? So if they aren't going to pay it, I don't think there's, other than there's all types of risk in this situation likely already. I don't think there's no particular reason why the employer should step up and pay that premium for the employee, right? So, and I'm not sure if it's on the next slide, but we did have a good chat about how an employer might be able to, pay the premium for the employee, which might be a solution where a plan requires 100% participation, but then recoup that cost from the employee later, like when they come back to work and they start working again. And I think you could do that, but you would need the employee to agree. That's the thing, because you can't legally deduct things like that from an employee's wages without their agreement. So I think that was something we chatted about prior to the webinar, which was a good suggestion, which is all I had. I think there are a couple of good questions we could answer quickly here on the last slide, actually. Do we give notice if not continuing regular benefits?
Yeah. So most benefit sections in an employment contract and in the benefits plan will have a changes section, right? That you can roll out changes if you give the employee 30, 60, 90 days notice. And so if you decide that you're going to put your employees on a layoff and you decide not to continue their benefits, we've had some people ask, well, do we have to just give the same notice that we would if it was any other situation where we were going to cancel benefits, for example? Again, if you're on that shaky ground of a questionable layoff in the first place, then you may want to give what notice you can, but practically, I'm not sure how people can. So it'll partly depend on how much that benefit package comprises the overall compensation of the person. If it's a very small, fairly insignificant, underused benefits plan, then maybe less of a risk. If it's a really robust benefits package, then you are looking at more of an adverse change that could start to trigger a constructive dismissal type of claim.
Mm-hmm. Yeah, so and I think notice of any change is a good idea where possible, but yeah. What if an employee gets sick while on a layoff but has no access to benefits?
I think this is your worst case scenario. Let's just put that out there right now. There's it's similar to there's a case called cont'd Kitchens where a person, contracts cancer during a reasonable notice period and the benefits were cut off. And then what happens, the court in that case said that the employer should not have cut off benefits and then puts them on the hook for not just the cost of the premiums, but the underlying cost of the coverage. And so I think here, if at the end of the day, we've got to see how the courts are going to shake down with all of this, in half a year, when we will start to see some constructive dismissal claims come through. And if it's like a worst case scenario where the court in your individual situation says, yes, there was zero right to do this, you did a unilateral unauthorized layoff, so it's a constructive dismissal, and then unfortunately and you cut off benefits, and now this person contracted some terrible illness while off, and but for the ceasing the benefits, they would have had access to these services. You could be on the hook for that actual benefit. Now that is a worst case scenario. I am not someone who thinks the sky is falling all the time. I do think there's going to be some layers of nuance in there to account for the fact that we're in this unprecedented global pandemic. But I do think, if possible, continue those benefits to try and head off that risk for sure. The other logistical issue around here is if they have no access to benefits, and maybe Hillary, if you want to flip to the next slide around this, what if the benefits that they're trying to get access to just don't exist right now because we can't have any in-person access? And so maybe, Gisela, do you want to speak to that? Because you've had some great creative conversations with insurers around how they're trying to pivot to the virtual environment right now.
So specifically in regards to paramedical services, and really the big topic right now is stress management, right? Health management. And we're all getting used to a new normal. And we really had no time to get used to it. So everybody reacts to change differently. So some carriers do have access to virtual services. So they are accepting claims for those services so that employees and members are still able to get services that way. Aside from that, what we're also seeing is a lot of carriers coming out with tools that are free of charge for employees and members to use in regards to health management, stress management, exercise. There's so much available right now within every insurance company that is accessible to the employer and to the employees. So I say make use of that, connect with whether it's your consulting team or your insurance company, and get access to those services, because there are ways that the industry is working on resolving this from the perspective of the employee and member experience, specifically driven towards health stress management. I know we had a question, and this is why the last bullet point is here in regards to employees raising concern about back pain and neck pain, and what is the responsibility of the employer to accommodate. Lisa, I'll pass it on to you first before I answer the question in regards to what's covered under the benefit plan.
Yeah, I mean, we've all had to pivot fairly quickly to home offices all of a sudden. So I mean, we've been working remotely at our firm for a few years now, but for the vast majority of businesses out there, they've had to make a quick pivot. And obviously not everybody has a fancy home office with ergonomic equipment. So we may start to see people bringing forward some ergonomic complaints. You know, it's not a comfortable, easy situation for some, but it could be an OSHA type of issue where, you know, they go ahead. Okay, go ahead.
I think this is interesting. I don't know how it's going to apply really, but the Occupational Health and Safety Act in Ontario does not apply to work done from home. So, but I kind of feel like we're, you know, now where we're forcing people to work from home, that's may change that. So, you know, yeah, I think that it could be implicated, because this isn't like people are choosing to work from home. The employer and, you know, our current situation is forcing people to work from home. So I think that's just an interesting element. But sorry, Lisa, go on.
No, that's a more clear answer than I would have given. So thank you.
But I think
the other.
Oh, go ahead.
Workers' comp as well is maybe a small corner of this, and they put out on their website this week that they will. This is brand new. I think maybe this was yesterday. This has been like one long week over the last month. They announced that they will not be providing any leave of absence benefits to workers who are performing modified duties as a result of a workplace injury and are sent home as part of a shutdown of operations. So they will continue wage loss benefits for people who are, you know, injured, and you know, despite their workplace shutting down because of a COVID issue. But they are putting out some commentary on what to do if it's a workplace injury that happens at home. So and this is as of last night, so I don't have my head completely around it. So if you do have people who are wondering about the workers' comp part of all this, the WSIB is starting to put out some information about this. So stay tuned. Hopefully we can just blog about this in the next week and get our head around what the exposure might be there for that. But what about insurance coverage, Gisela?
So from the benefit side of it, it would not be covered under a regular employee benefits plan. It could be covered through a personal savings account, which is basically an employer decides a figure per year that they would give per employee for that employee to use that kind of account. So let's call it $500 per year. I have accessibility through a personal savings account to use it towards gym membership, fitness, vitamins. So it's something that could fall under that type of service. However, it is taxable in the hands of that employee. So it may defeat the purpose of the employer accommodating. So the recommendation would be to do it under a business expense as opposed to putting it through the employee. What would be your thoughts on that from a legal perspective?
You know what? I think this is, for me, this is like a stage 2 issue, right? Right now, we're all trying to figure out how to get through the immediate surge of exposure and dealing with the adjustment home. But if people start to make claims down the road of needing either ergonomic type tools, and then how to claim for them, what are the tax consequences of all that, I actually think, and I've been advising many clients to do this in 2 stages. Just get through today and figure out, if you are a public facing business and now you've got someone who's just tested positive for COVID, get them off the road, get them, shut down your business if you need to, and then deal with what some of the consequences are. I think it's too much for any one of us to handle in one step. So that's probably a long way of saying I don't know what the answer is, Gisela.
But we don't know, right? Because we don't know how courts are going to interpret these pretty widespread actions that aren't really they aren't by the book as we may have advised before everything changed. So yeah, I'm just gonna, I know it's after 1, so I'm just gonna go to our next slide, which I don't know if there's anything on here you guys are dying to answer.
These are some of the more practical frontline questions that we're getting from people. So it's less about benefits, so we could probably skip it. But the one question that I think, Gisela, you got from one of your clients was, what risk do we have if you are an essential service required to remain open, and either you have an employee who tests positive for COVID or they're exposed, right? If they're in a business that's on the essential services list that each of the provinces are putting out, and you still have to stay open, like if you're a land survey company or your professional services, or there's a bunch that are a liquor store worker, if you have to stay open, what happens? And I think this is where we'll see what happens with WSIB, with OSHA type complaints. I know Service Canada has had to deal with this. The Service Canada workers, as of last night, they kind of deal with their union, where all Service Canada offices are now closed to the public effective today. This is how fast everything is changing. So today, you need to do all of your Service Canada stuff, all your EI applications, online or by telephone. They will make some exceptions if there's an accessibility issue, but it was the workers who finally just refused to come into work. Really awful stories of frustrated members of the public pretending to cough on people and threatening them, and this is really, really gross stuff. So with some union advocacy there, they did shut down it to the public. But so I think if you're an essential service, and Service Canada is probably one of our most essential services now besides the healthcare front lines, it's going to be a case-by-case basis to figure out how you work through the logistics of this. And then our stage 2, and maybe we should just have another webinar in a month, how do we deal with the after, the fallout of all of this? We're right in the middle of the crisis right now.
I would also just add to that, Lisa, just to employers who are trying to protect themselves from liability, is you want to, if you have an employee who tests positive, you have to remain open. Document carefully what steps you're taking to protect your other employees. So, are you now like checking everyone's temperature when they come in to screen, make sure no one has symptoms? Document when you're cleaning, right? Like if you've increased like Lysol spray down, document that, like I did it this hour, because those are the things. If an employer is sued later because an employee is sick and says my employer didn't take reasonable precautions, you want to have that evidence. Oh, I did take reasonable precautions and we had to stay open because we're essential, but these are all the things I did. Like on this date, we installed those plexiglass screens or whatever, right? So, make a record, I would say, and just take those precautions and talk to public health about what you should be doing. And I think as long as you're following advice, like advice that we can't give, but advice about sanitization and whatnot, then what more could you have done, right? That's the position you want to be in if you're in court. What more could I have done?
And Hillary, do we have any other questions?
We have about 1 million questions. So I don't think we want the webinar to go all day, and I am seeing our numbers dwindling. So I don't know what you guys want to do.
Let's do like 5 minutes because less than half have dropped off. There's still a big number of people on. So let's do the last few questions here.
Oh yeah, why don't we do and then the questions on the slides, they came from people too, right? So these are real scenarios that we've been addressing. If we're not getting to your live question, you can email us.
One of the questions that's come up, it's regarding what we call in the benefits world a premium grace period. So when the bill is due, employers have a month of a grace period to make payment. Insurance companies now have extended that grace period to 60 days. So how should payroll be dealt with when there is a co-payment in place?
We've gotten this question from a bunch of clients that, if they have a third party, an ADP or Ceridian type of payroll provider, the logistics of this are really tricky for people who are on a layoff, who are annoyed that they're on a layoff and aren't getting money. How do you get any payments from the employee for their portion of it, and then the sorting it out with your payroll provider. The logistics of that, I mean, that's less of a legal issue in my mind, and more of a practical issue of just calling your payroll provider and seeing what are some options available on that front. Hillary, do you have any?
Some of the things that we're seeing from our end is just employers are still deducting if they can. And just for the ones that are not able to come up with payment because of a layoff, they are paying for those premiums on behalf of those employees, and then just working out a structure where they pay the premiums back once they're back at work. So that's some of the scenarios that we are experiencing. But you're right, Lisa, it is more of a payroll as opposed to legal, but certainly a question that's come up quite a bit in the last few days.
Yeah. Hillary, do you want to should we just do 2 more questions off the line, and then that way people can, people are staying on, so I think there's a lot of questions that people have, but if we could maybe just do 2 more.
Sure. So we are registered already for a supplementary unemployment benefit program for maternity leave and sick leave. Do we need to update EI if we choose to give supplementary unemployment benefits to regular EI benefits or the new CERB benefit? So I would say yes, you do. Yeah, because it's certainly a different stream than maternity leave top up and sick leave top up. We don't know how the CERB benefit is going to work with the supplementary unemployment benefit top up. So we don't know if if that's going to be something that you can top up, I would expect so. But because it's more targeted to people who wouldn't be eligible for EI, though available to people who are eligible for EI, we don't have those details yet. But I would say you should register your supplementary.
And the practical reason why you would want to is that if you don't, then if the goal here is to try and keep your employee as whole as possible, to give you more options of how to organize your workforce temporarily, if you don't register it, then then their EI payments get it all gets set off from each other, and they won't get the full benefit of being topped up.
So this question, someone's put it in twice, so I better answer it. For those who have applied for EI but would make more going on the CRB, will they have the option to change their choice? And as far as I know, if you have an employee who's already applied for EI, they're kind of stuck in the EI stream. So there's no, the government's not going to like switch you because you could be making more in CARB. So I think you probably could stop EI and at some point, and then switch over to the CARB. That would most likely create some delays in getting payments. And EI generally does take about a month to start anyway. So, but I think the government has actually asked people not to cancel their EI application and switch if they've already started that EI application. And I think that's just simply because, EI is overloaded and maybe they already started on it. They don't want to have sort of duplicate work there. But again, like, we don't have all the information on the CARB yet. It's just announced 2 days ago. And the applications are not available yet. So that's what I think right now. But
if I can do a quick plug, we and Giselle, you should feel free to do so as well. SpringLaw has a blog, and we have an FAQ sheet that we've been updating as regularly as we can, daily sometimes. So we have a bunch of resources available on our website for the for everything that's going on right now. So, I mean, that's a great question about the CERB. We don't know yet. We haven't seen the application yet. It hasn't come out yet. So as soon as we do, we will be sure to update. You zipped through the takeaway photo too fast. We have to say the joke about the toilet paper. You know,
sorry.
Our medical advice for you is that toilet paper is not the answer.
Good. There's a picture of toilet paper.
Thank you.
Got it.
There you go. It will not cure COVID-19, so stop hoarding toilet paper. We are in uncharted waters, and so we're trying to give updates in real time as we can. We have our blog, we have our FAQ sheet that we're updating all the time. We're doing webinars weekly at this point. But Gisela, what resources can you share that would be helpful for people?
I think for all of those employers that have an employee benefit plan, continue to go to your insurance company's website, because things are changing daily. Again, as the government changes their stance, as things evolve, so will your employee benefit plan and the offering that you currently have. So make sure that you're looking out for the tools, free tools in a lot of cases that are available to you. One of the questions, for example, was on travel. What happens if I'm in an essential service and I need to travel for work, and now I have COVID-19? You will be covered. So there's things that are changing. And of course, there's much more info that I could give you on that. But the reality is stay in touch with your carrier, stay in touch with your consultant, with your broker, so that they can guide you, navigate the daily changes that we are receiving because of how this is all evolving. Great. And then keep in touch with your team. There's so many resources, so many things that we could be doing to stay positive as a community. So tap into those. Tap into exercising online, yoga online. I know I'm doing my yoga. I'm still trying to keep up with that, to keep my sanity of dealing with my kids 24/7. So as much as I love them. So there's a lot of things available to us right now. to
I think
come
they
out of
should
this as a stronger community.
introduce a new benefit for homeschooling working parents who, are going crazy right now. But,
Yeah.
it's a great time to just shut down all the extracurricular activities that people have with busy kids, and to regroup at home. I mean, it's not all bad. It's scary out there in terms of the exposure to COVID, but it's not a bad thing to have our schedule switched up a little bit and get a little less busy and have to stay home a bit. I mean, our areas, we're
not that busy.
we've been working around the clock for 2 weeks, but and I know there's a lot of panic out there, a lot of very worried businesses, it's and workers that, it's a tough go out there right now, but we'll get through this. So if anyone has any other questions, which I know we do, and there's still a whole bunch of people on the line. Thank you for staying and bearing with us and sticking to the end. I know that I think our room was full today as well, so we'll have to send out an email to people who were unable to get in. I know we had 2 people on our own team that dropped off near the beginning to make space for people. So I know that it's been hard to get into the room for some. So we will be sure to send the link out so that people can get access to the full content. And we'll have to update the content, within a week, because things are changing so quickly. If you have any benefit-specific questions, please contact Gisela. There's her website and her email address, benchmarkbenefits.ca. Any employment law questions, feel free to contact Hillary and I directly. Any closing remarks from either one of you that you'd like to say?
I say thank you. Go ahead.
I just wanted to remind people that they can download the slide deck in the handout section. I think we maybe mentioned that before, but we do have links in there, and so there's some good resources in there. And just another plug for our FAQs. I think some of your questions that we didn't get to may be in those FAQs on SpringLaw website and blog, so that's a good place to start as well. Sorry for cutting you off, Gisela.
That's okay. I just wanted to say thank you so much. Thank you for your time today, guys, and for our attendees. We appreciate you staying with us to the very end. 45 minutes turned out into an hour and a half. I appreciate the time, and we will definitely keep in touch as things evolve and change. And as both Lisa and Hillary said, we're here if you have any questions or need any assistance as we navigate these evolving times.
Okay.
Thank you.
Bye-bye.
Thank you. Bye-bye.